long way from Massachusetts. It's warmer and nice.
At that table there.
Fill up that back row.
Go like in. Is someone
Bring him down.
Good morning, everybody, and welcome to Arizona Law. It's a great day in the life of the college, a loud day in the life of the college. Is that where you want the sound to be, Taylor? Okay. Welcome to Justice Breyer, to all of our distinguished guests, in particular to the Marks family for making this possible. We are forever in your debt. This is the 29th annual Memorial Marks Lecture. And I want to first go over the rules. We have just a few of them. If you have a cell phone, of course, please turn it off. If you have Blackberries and pagers, my condolences. If you have a GPS, that's great that your family can find you, but just not now. Any satellite dishes, please tuck them underneath your seats. Anything electronic that you brought into the room with you, I suggest that you turn it off. There's no photography allowed except for the credentialed news media, and they are allowed to take pictures only in the first few minutes of the lecture. You'll be able to find these remarks on the Arizona Law website later this week, and we have a multimedia website that makes it possible for you to enjoy our presentations multiple times and to share them with your friends. Finally, at the end of the lecture, our speaker will exit first, followed by the Marks family and their guests, and I invite everybody to join us in the lobby of the law school for some refreshments after the remarks. We expect to finish up shortly before 11. There's a class that comes in here afterwards. If there's time permitting for questions, we will take them at that time, but I hope you will understand if we need to stop sharply at 11 in order to vacate the room. About the building, for those of you who have not been back to see the renovations, I hope you enjoy them, walk through the building and have a chance to see what the community, working with the university, has done to make the place a much more student-centered place, and we believe a much more community-centered place. And so we hope that you will enjoy our new surroundings. As I noted, this is the 29th annual Marx Memorial Lecture. And I want to pause for a moment to reflect on the many intellectual gifts that this series makes possible for us. For almost 30 years, we've been the beneficiaries of this lecture series. We're scholars of international renown, journalists, authors, national newsmakers, and yes, Supreme Court justices have been kind enough to come here and share their thoughts and to enable us to participate in the world of ideas right here in Tucson. We can't reflect meaningfully on this without reflecting on the contributions of Selma Paul Marx. Selma has not only been a steadfast friend of this college, she's also been a steadfast friend of the Social and Behavioral Sciences College here on campus. The alumni outreach that happens here happens with her contributions. She's been a longtime member of our Board of Visitors and our LCA, and she is also the recipient of the highest award that the college gives, the Lifetime Achievement Award. I'd like you to take a moment to have us collectively thank Selma Paul Marx and the Marx family and welcome her son, David, here today. As you can read in the brochure, this lecture series honors the late Judge Jack Marx was Selma's husband, and they together decided to recognize Isaac Marx, who was a lawyer's lawyer. And this series, as she was saying last night when they contemplated where to locate the series, there was discussion of having it at Columbia. And Selma said, "Thank you, no. Let's have it right here in Tucson." I think that it was good to end the bicoastal imperialism that sometimes governs these affairs. I also want to take a moment, see where she is sitting. Sally Ryder is the director of the Rehnquist Center. Sally, are you in this? Please stand. In the short time that Sally, who is an alumna of the college, has been with us as the director of the Rehnquist Center, she has single-handedly been responsible for bringing a dazzling array of speakers here to Tucson. Tomorrow we will have our second Rehnquist conference here in Tucson, The New Media and the Courts, focusing on the very interesting question of how is it different that people relate to major institutions like the courts when the reporting that's being done on them is coming in the new forms of blogging and things of that nature. She's been a remarkable administrator, teacher, and friend of the college, and we're extremely grateful to all of the intellectual richness that she brings to us as well. I now want to turn to our guest and mention, among other things, that Justice Breyer is on the board of the Rehnquist Center and has contributed meaningfully to enabling us to give this center such a great launch. The center focuses, it's a nonpartisan center that focuses on the constitutional structures of government. And he is a wonderful person to contribute in that way if you know about his stellar career. Just some of the highlights of this remarkable man. Justice Breyer was nominated by President Clinton as an Associate Justice of the Supreme Court of the United States and was seated on the court in 1994. At the time of his nomination, he served as Chief Judge of the United States Court of Appeals for the First Circuit. He also served as a member of the Judicial Conference of the United States and of the United States Sentencing Commission. He received his A.B. from Stanford University, a B.A. from Magdalen College, Oxford, and his LLB from Harvard Law School. He's overcome his modest educational beginnings, however, and has contributed exceptionally to our profession and to our country. He clerked for Justice Arthur Goldberg of the Supreme Court of the United States during the 1964 term. He served as special assistant to the Assistant U.S. Attorney General for Antitrust from 65 through 67. Assistant Special Prosecutor of the Watergate Special Prosecution Force in 1973. Special Counsel of the U.S. Senate Judiciary Committee from 74 to 75. And last night at dinner, Senator DeConcini commented on his spectacular service in that regard and how he was absolutely the most exceptional person who worked with that committee. He also was chief counsel of the committee from 79 to 80. He's been an assistant professor, professor of law and lecturer at Harvard Law School, a professor at the Harvard University Kennedy School of Government, a visiting professor at the College of Law in Sydney, Australia, and the University of Rome. Now, he is also the proponent of a concept called active liberty. It is the profound idea that democracy requires the thoughtful and deliberate support of the people, we the people. It involves not only our understanding of the Constitution and what flows from the document, but the ways in which freedom and liberty play out in everyday contexts, and the ways in which the Constitution is a living document through our communities, our workplaces, at our public meetings, in our courthouses, and throughout the world. He's a leader, along with Justice O'Connor, in advancing much greater understanding on the role of the judiciary. He is an intellectual force on the court, the author of an extremely important book that is a counterpoise to intellectual thought that focuses on a more formalistic and originalist interpretation of the Constitution. In all of these endeavors, he is a leader. He's also a wonderfully engaging person and an athlete. I learned about that this morning. Please join me in welcoming Justice Breyer.
The microphone doesn't like what I'm saying. It's all right? Sounds a little. Is it better or worse? Yeah, okay. Better. Okay, good. Anyway, I wrote a book, and it got into the hands of a reviewer, and it was about regulation, and this is what the LA Times says. In Alice in Wonderland, Alice and the Dormouse emerge from the pool of tears, at which point the Dormouse picks up Hume's History of England and begins to read. "Why are you reading that?" said Alice. "Well," replied the Dormouse, "we're wet, and this is the driest thing I know." That, he added, was before Judge Breyer wrote this book, obviously. So, there we are. When you say I am writing a book, that's true, I am. And also, supposedly, some anthropologist found in the ruins of the city of Ur tablets which said, "This is a bad time, bad time. Children will not obey their parents. The buses don't run on time. And every man is writing a book." But there we are. Now, I titled this lecture Remarks, because I had no idea what I wanted to say. And I was actually debating two choices which I couldn't decide between for quite a while. Now, I was rather like, now hardly anyone in this room will remember Jack Benny. Let's see, total blank. Jack Benny was quite funny as a comedian, and he was supposed to be very stingy, and he was a great comedian when I was growing up, years and years and years before you were born. And we'd listen on the radio, and one of his routines was a robber would come up to him, he'd be there with his wife, and say, "Your money or your life? Your money or your life?" Jack, his wife would say, "Boy, answer now." I'm thinking. That is the way I've been behaving towards the subject of this lecture. And I worked out that the first thing I wanted to talk about, which was judicial independence, I probably actually spoke about roughly 2 years ago when I was here, or at least parts of it. And though I have yet to find one person, including me, who can remember what I spoke about 2 years ago, I have a sneaking feeling in the middle of it you might think this sounded familiar. So I think what I'll talk about instead for about 40 minutes or so is a case, Dred Scott. And to give you a little context, why I became very interested in Dred Scott is this. There is a big question that surrounds our court like every court. How do the judges decide these questions of enormous public import, which are also of great political interest, where the right decision may be a decision that is exceedingly unpopular? Now, can we say something about that? Now, unless I can say something about it, I'm forced to accept, though I disagree with, the general view among journalists, many who study the court, scholars and others, that there are only two choices. And choice number one is that there's some kind of theory of interpretation somewhere, originalism, for example, and when you apply it consistently, you will, in fact, get results, like sort of putting it into a machine, and out comes the sausage. And there we are, a computer. That's my parody, not the view of those who hold that view. But some kind of system for deciding these things, which I don't think is right. Or, what these 9 people are anyway, a group of junior politicians that, although they don't know it, and maybe can hide it from themselves even, what they're doing is actually deciding matters according to their political beliefs. What they think politically is basically right. I don't think that's right. And so we find people oscillating between those two. And what I really believe is it's neither the one nor the other. So it's a fair criticism of me to say, well, what is it then? Tell us if you were so clever. And that's what I have put out in front of me as a kind of objective. And, of course, I won't get the answer. I will not get an answer. But I can, in fact, do my best to sketch out the kinds of things that I believe hold me as a judge in check. Now, there's a second thing I want to say about that, because I think it is related to the following question. When Hamilton and Madison and the others wrote the Constitution, it is absolutely clear that they were writing a document they expected to last for many centuries. So it had to work. And when they came to the part about who will have the last word in interpreting the provisions of the Constitution, they thought the judges. I think that's pretty clear. John Marshall did not make it up. This was, in fact, something that was in the air and on paper in the Federalists. And Hamilton makes an argument as to why that should be. Why should the judges have this power rather than, say, the people directly or through their legislature or the president? He addresses that, and if you allow me to parody his answer slightly, it is along the lines of the old joke where the rabbi or the priest, depending on who you want to use, goes to a total foreign parish. He doesn't know anyone. He's helping out his friend. There is a funeral, and he doesn't know a soul, and he says, I don't know the deceased. Will somebody else please come up and say something nice about it? Please. You know, I don't mean a long speech. I mean a short speech. Just say a few words. Just one word nice about the deceased. Please. And finally, a little old man from the back raises his hand. And he comes forward and goes up to the front and turns to the assembled congregation. He says, well, his brother was worse. Now, that is Hamilton's argument for placing judicial review in the hands of the Supreme Court of the United States. He says, consider the alternatives. President, you'll make him a king. He'll feel he can do what he wants. The legislature, that's a tough one. It's a tough one until you begin to think that it's quite possible they will do something that is intensely popular. And that intensely popular thing will happen to violate the Constitution. Can you really expect them to say that this intensely popular thing, which violates the Constitution, is itself unconstitutional when they already believe it isn't? Otherwise, why'd they do it? This is not a very safe check in the hands of a Constitution, in the hands of a legislature where that Constitution is meant, in part, to protect people who themselves are unpopular and in a minority. So we're left with the judges. Cross our fingers. And he says a few more words about that. But he doesn't answer this question. Mr. Hamilton, very logical, very sensible, very sound, but how do you know when the judges, and maybe they will write that opinion that protects the minority, that follows the Constitution, when doing so is intensely unpopular, how do you know people will do it? How do you know they'll follow it? A question that we hardly ask. We don't need to, perhaps. How will they do it? And that is a question. Call that the hole in Hamilton's argument. And what I think is, and this is what I'm not talking about this morning, you're only getting a small part of it. Part of that depends on people's attitudes. And those attitudes you can show have evolved through things I talked about in part last year. The Cherokee Indian case, where in fact the President of the United States said to the Chief Justice, enforce it yourself. And instead of following the law, which was that the Cherokee Indians owned northern Georgia, and the Supreme Court opinion, which said the same thing, he sent the troops to evict them. That's a story. And it suggests maybe there was a hole in Hamilton argument. And it also, John Marshall and Joseph Story knew it. They were in despair. And then as you go forth over time, I've talked about here, too, the Craig case, I think, Cooper versus Aaron, where President Eisenhower sent troops to Little Rock to enforce a court order to take the black children by the hand, effectively, and into that black school, white school, black school, integrated school now. It was the school that Governor Faubus said, we'll never be integrated. And that moment of sending in the paratroopers is important. Critical, indeed. Although, by the way, that's not the case that we remember from that period, which I think many of you will read later, called Cooper versus Aaron. Because what happened, if you'd like to know, is that Eisenhower, who'd been of two minds, why? Because Jimmy Burns, the former governor of South Carolina, who was a Democratic appointee, a good friend of Harry Truman, came to Eisenhower and said, if you send in the troops, that'll make matters worse, and what's going to happen is you're going to have to occupy the entire South, and once you've occupied the entire South, they still won't do it. They'll close the schools, and then nobody will be educated. That's what's going to happen. And sitting there in advance, Eisenhower isn't sure. Absolutely the right thing. He sent in the troops, and it worked. It worked. Well, did it work? What happened next is that the school board says, well, we can't do this in the face of the gubernatorial opposition, and asked for a 30-month delay, and eventually the Supreme Court, after deliberating like mad as to how to say it, said in Cooper versus Aaron, school board, keep doing it. The black children are in the school now. Keep them there. Integration, no delay. All 9 judges sign it. And boy, when you look at those internal deliberations, they understood that they are deciding this for the country forever. So after the, well, it's quite a big deal, very important. They wrote it. The next day, Faubus closed the school. And that school stayed closed for a year. But that was unstable. So I look back at that. And I like that uncertainty about what would happen. But basically that stood for, yes, the President of the United States will send troops to enforce the law, and people will do it. And now think of Bush v. Gore. I know. I was in dissent. Okay? So, all right. But I think it's wrong. Okay. I wrote that down. No sticks. No rocks, no paratroopers. And I heard Senator Harry Reid discuss that, and he said the most important thing, the most remarkable thing about that case is exactly what is hardly ever remarked. Just what I said it was, too. No sticks, no stones, no paratroopers. And the public has come to accept the fact that I don't follow this opinion because I think it's so awfully wrong. And then one day there's going to be one I think is right, and you won't follow it. And that way lies chaos that I see every day in the court. It's the greatest thing of every race, every religion, every point of view. 300 million people in this country. 300 million. Of everything under the sun. And what ties them together, and I see it, is that document, and they've decided to come into court and decide their differences under law. That is a treasure beyond belief. And that's what Harry Reid means. He means focus on this from time to time. And if you look back into the history and you say, is this a guarantee for the future? There are no guarantees. In political life, as in life, there are no guarantees. You have to work at it. And that's last time's lecture, sort of. And now we'll come up to this year's lecture, which is, and then we'll not end it. So I can have next year's lecture or the year after. But I'm going to bring you to where we are because I'm only half through there, because all that I've said there is we are inheriting a world, luckily for us, and are right in the middle of it, and you inherit it. And in that world, this tendency to follow the law, even when it's wrong, even when it's unpopular, is very, very strong. And that is a tremendous strength of the country. But what about the judges? Let's go back to where I started. What are the implications for the judiciary and the way to decide? And here I will tell you a story, and that is the next 30 minutes. And this is the story of Dred Scott. And I will tell you right up front that it is the story of what not to do. It helps if you can begin with what not to do, if in fact you can understand why it's what not to do, and not just say, it's not hard. You see, I want to explain just precisely, with a cold, calculating eye, what is wrong with this case. We all know, most of us, that if you look up in the Oxford Dictionary of the Supreme Court, you will see that they say this is generally acknowledged to be the worst case ever decided in the Supreme Court. And if you look at scholars and what they all say something consistent with that, probably worse. So naturally, when I read that, I thought, how could they all be right? I immediately read it. I'm going to find something good about it. Well, a little hard to find something good about it. And the best I can do at the moment is to say it's so bad it's good, which is what Frederick Douglass said, who was a great abolitionist afterwards. But why? That's what's interesting. That's what's interesting. Because there's where the lessons are, I think, from which we will depart to try to say, well, what is it that these attitudes ought to be in the minds of the judges? Let's start with Dred Scott. At the beginning of the story, the factual story, who is Dred Scott? Dred Scott was a slave. He's born in the early 1800s in Virginia. He's owned by a family named Blow. They fall on hard times. So the Blows were apparently quite nice, and he was raised with the Blow children, and they were friends. He's sold to Emerson, Dr. Emerson, who is an army doctor. Perfectly nice, but not only is an army doctor, he's a hypochondriac, and he spends most of his time trying to figure out how to get out of the army and traveling around from place to place till he can find a general at some fort or other who will let him out. But nonetheless, he was the owner of Dred Scott, and he lived in Missouri for a while. Then he moved to Illinois, a free state, where they lived for 3 years, Dred Scott and him. And then he moved to Fort Snelling, which is up in Minnesota, which was then part of the Missouri territories, and it was a free territory. That is, under the Missouri Compromise and under legislation passed by Congress, no slavery. And slaves who come in there are free. And then, after a while, he got married there, Dred Scott, Harriet, who was a forceful woman, apparently, from what I read. And she appears in the story once they moved back to Missouri. On the way, in free territory, she had a child, Elizabeth. And she had another one later, but that might not have been until they got back to Missouri. Now, Dr. Emerson is still having trouble with his health, and he did finally die, and he left the Scots to his widow. And Harriet began to get nervous about this whole situation because she was afraid of how they might be taken care of in their old age. And she got, I think, Dred Scott and she together brought a lawsuit because they had friends, and the friends knew people who were lawyers, and those lawyers told them they were free and said they'd represent them for. So they brought a lawsuit in the state of Missouri, and in that lawsuit it eventually went to the Missouri Supreme Court, and everyone expected the Missouri Supreme Court to say they were free because they'd lived for 5 years in free territory, been married there, were residents of free territories and free states, and the precedent in Missouri was they're free. You're free, you're free. And in fact, the Missouri Supreme Court surprised everyone, and the general view of that by the scholars is they overruled 37 cases and said you're not free, you're a slave. Luckily, perhaps, they didn't quite finish the case. It was sent back and it was held on the docket. So now for the procedure students, this will be interesting. Not for anybody else. But while that case is pending, they bring a suit again, the Scots, in the federal court. And this time they sue Mrs. Emerson, who by now is remarried, moved to Massachusetts, and somehow in the middle of this case, she transfers the ownership of the Scots to her brother, Sanford, who's a resident of New York. The district court says, well, Missouri said you're a slave. I'm sorry. It's a matter of state law. They say you're a slave, goodbye. They said it a little bit more lengthy, but no need to go further. And now, Scott takes an appeal to the Supreme Court, which agrees to hear it. And by this time, it's a pretty big issue in the country. Why is it such a big issue in the country? The reason that it's such a big issue is slavery is dividing the country politically. These are the 1850s. The Civil War is right on the horizon. And each side, the North and South, suffers from a degree of political paranoia, and maybe based on fact. The South is thinking, when this Constitution was written, we had written into it guarantees of slavery. Now, they can't mean that it says in the Constitution importation of slaves is okay, because it says 1808 has a deadline on that, and this is long past the deadline. Well, what do they mean? Now, many of you know what they meant, but some do not. If you read a clause that today is not often read, you will see the clause that determines how many members of Congress there are from each state depends upon the census. It depends upon population. And the key language said that for purposes of counting how many people are in a state, a slave will count as 3/5 of a person. The South's point of view, perfect. We get to have our population count as 1.6 times the others. But, of course, we're not going to let the slaves vote. And so, therefore, we get, in the South, 1.5 to twice as much weight as anyone else. And we have a lock on the legislature, the House. They thought that was great. And for a long time, it worked. And it was virtually impossible to get anti-slavery legislation through. But what they had thought would happen at the time they wrote the Constitution, and they were only I guess, 100 and 200 years off on this. They were right, but 200 years off. That the new immigration and the center of the population would move south and west. And if it moves south and west, as it subsequently has, if it moves south and west, they had a good chance of influencing the new states to become slave states and maintain their law. But that didn't happen because the immigration went north, and they wanted to be free. And therefore, the South lost its lock on the House of Representatives, and they begin to think, and what about the Senate? Each of those two new states is going to be 2 free the slave senators, and we're doomed. Well, what's the North thinking? Great. Not everybody, by any means, but many of the abolitionists think this is a good idea. This is fabulous. But wait a minute, we understand them, and they're not stupid. And they're going to sit there in the South. They're going to think of something. And I think what they're going to think of is figuring out a way that the Constitution will force us to admit these new states as slave states, or to tolerate slavery in these new states that come in out of the free territory, or to tolerate slavery up there in the Northwest. So each is very much afraid of what's going to happen to the legality of slavery or keeping slaves in the new territories, and they are right. Their thinking is right at the top of the political agenda. So, Dred Scott's going to be taken. This is a big deal in terms of the politics of the nation. Everybody's worried about it. Now, at that point, it's argued again in the Supreme Court. Of course, new lawyers for Dred Scott. One of them, Curtis, was the brother of one of the Supreme Court justices. They weren't too strong on ethical principles in those days. But it's well argued, and now it's about to be decided. And, I mean, all kinds of things went on. James Buchanan apparently was told about the result of it before it came down so he could make favorable references to it in his inaugural address. We'll leave that out of it, the sort of extraneous. Now, the first thing we've learned happened at the conference was this. It's assigned to Judge Nelson, and he's going to write 2 paragraphs. And he's going to say, Missouri decided it. We go along. We can't overturn what Missouri says. Poor guy. Goodbye. End of case. And then something happened. It may be that Curtis said he was going to write a dissent. And Taney said, you write your dissent, I'll write my majority. You won't like it. Taney, by the way, was Chief Justice. He was a slaveholder originally from Maryland, released his slaves, freed his slaves, not a dedicated slaveholder, gave some talks very much against slavery, and some in which he characterized slavery as a blot on the national conscience. But strong Jacksonian, believes in states' rights. His sympathies, certainly judging from this, were pretty pro-slavery. And an intelligent man. The Attorney General, Taney, said he has a moonlight mind. He said, well, what's that? He said, well, it has the brightness of the sun without the glare. Okay. But there we are. And he has taken charge of this case, and before you know it, he's written an opinion, and Curtis has written a dissent, and it's 6-3, and down it comes. Now, what is this case that has given rise to these condemnations? Here is what it holds. And I think most people never get beyond holding number 1. And holding number 1 was bad enough. But when you get to holding number 2 and 3, my goodness, you're going to have a tough time saying which is the worst. Why? Well, I'll track along what the court said through Taney, and then what Curtis said in reply. Because Curtis is the main opinion, which is cold, logical, He says this, but. He says that, but. He says this, but. Okay. Issue number 1. Can Dred Scott bring this case? Well, why not? Well, the Constitution says that the Article 3 courts, the federal courts, the Supreme Court, have the power to hear only certain cases. And the relevant clause that governs this one is cases or controversies between citizens of different states. Now, Taney says, look at those words. Citizens of different states. Is Dred Scott a citizen? Now, one of them, Sanford's New York. Nobody else is from New York. But what about Dred Scott? Isn't he a citizen of Missouri? At least if he wins the case. So Taney says, fair enough, I'll take it. Assume he wins the case. If he wins the case, he is a freed African slave. So I'll say is a freed African slave, a citizen of another state, a state other than New York. And he says, well, I'll assume Missouri would say he's a citizen if he's free. There were a lot of authority on it. In order to be a citizen of a state for purposes of the Constitution, you must be a citizen of the United States. And is he a citizen of the United States? Well, on this one, no. Why not? Why not? Well, here is where he went really over the top. And I rather hate to read this because it's so awful. But at the time, it was thought awful. It's not that I'm using hindsight. It is not. You go back and read what people thought about this language. And what he said was, public opinion at the time of the Constitution considered Africans so far inferior to the white race that they had no rights which the white man was bound to respect and might lawfully and justly be reduced to slavery for his benefit. Charming. And that was, in fact, the view that his argument picks up. Because he says, now, I understand that Jefferson wrote the Declaration of Independence, signed by so many of the others, where they said all men are created equal. And I know that the Constitution starts, we the people, but they didn't mean black people. Because if they did, well, they're hypocrites. Because most of them were slaveholders. Huh. What do you say to that, Justice Curtis? And besides, while you're thinking, he says, I'll tell you a couple of other things. Let's go to New Hampshire. New Hampshire is supposed to be the bastion of the freedom for the freed slaves, an abolitionist stronghold. Let's look at Massachusetts. Let's look at Connecticut. And I'll tell you what you're going to find. Right there, you're going to find anti-miscegenation statutes. And you will find a statute that says no black person, i.e. no freed slave, i.e. no former slave. No, it's definite. We know who you're after, and you are not serving in the militia. You can't. So he says, well, they didn't make them citizens. Can't serve in the militia. What do you think that anti-miscegenation statute is about? The framers never meant to include them. And by the way, my final point, he says a fabulous point. He quotes some federal statutes, which seem to say citizens here and colored people there. And says, see, if they're citizens of the United States, then a freed slave in one state, let's call it New Hampshire, travels to another state, let's call it Louisiana, and we must give him in Louisiana all the privileges and immunities of an American citizen. Oh, that, he says, is unthinkable. All right, there's the argument. Well, Mr. Curtis, what will you say to that? No, Curtis says, it isn't as tough as you seem to imply by your tone of voice. He says, I'll tell you a couple of things. First and foremost, 5 states made freed slaves, black freed slaves, citizens of those states at the time the Constitution was written. Massachusetts, New Hampshire, North Carolina, Connecticut, Rhode Island. How do you know that? They voted. They voted. They let them vote. And do you think when they wrote this Constitution that they would have thought that a person who's going to vote on its ratification isn't a citizen? And remember, it doesn't say citizens of the United States. It says citizens of a state. And that's up to the states, not to the United States. So what's the problem? And just in case, in North Carolina is not the bastion of abolition. In North Carolina, here is an opinion of the Supreme Court of North Carolina, which says that the freed slave is a citizen of North Carolina. So I'll grant you, in those states, there were citizens that were not allowed to serve in the militia. Well, women couldn't either. And it's also true that there were miscegenation laws. That doesn't show they're not citizens. Neither does. It just shows they're citizens that people are discriminating against. That's a different thing. And as far as your language, And as far as that language showing what the framers thought, here's what he says about that, which I rather like. He says, I shall not enter into an examination of the existing opinions of that period, the founding period, respecting the African race, but a calm consideration of the assertion in the Declaration of Independence that all men are created equal, a calm comparison of that phrase with the individual opinions and acts of its authors would not leave these men under any reproach of inconsistency. Now, first, I think most people, most historians say is absolutely right. That certainly Benjamin Franklin, you think when he wrote the words or signed onto them, was thinking they didn't include everybody. I mean, it was, after all, Enlightenment principles that they were writing into these documents, and those principles included everybody, and they were slaveholders, that's true, but that doesn't mean they failed to hold an ideal. And in fact, I guess the historians tell us, if you look into it, George Washington and the others expected slavery to be abolished. They didn't see it as a good thing to keep. They saw it as a divisive issue necessary to compromise about now in order to make certain the South comes into the Union. But it'll go. Now, that's what he's saying. And he elaborates on that. He says, please, nobody's heard your principle before. And as far as the Privileges and Immunities Clause is concerned, and he finds federal statutes the other way, but as far as privileges and immunities is concerned, I'll tell you something. I looked into the history of it. And doesn't this sound like a legal argument? It does. I mean, it strikes me as a good legal argument. He says the history of this Privileges and Immunities Clause says that it comes from the Articles of Confederation. So let's turn to the debates there. And what you will see when they're talking about the language, which says all citizens, every citizen of a state, you'll find that the Southern delegations moved to insert between the word every and citizen the word white. And that was voted down. And they knew why they were voting it down. And the language that says every citizen instead of every white citizen is the language that survived. So if you tell me it's unthinkable to have the Privileges and Immunities Clause apply to black citizens, I'll say that's what they thought. And show me where I'm wrong. So I think on that one he has a pretty good argument. Pure legal argument. Argument number 2. What Taney says. Now he says, Dred Scott can't sue. We don't have the power to hear his case. He is not a citizen under Article 3. Now, my parody of what he says. But as long as we're at it, let's decide a few other issues that are going to divide the country. What he actually says is, well, you see, I know normally you just dismiss it. That's the end of the case. But you see, there might be some people I didn't convince. And everybody will agree that if he's a slave, he can't sue, so let's consider whether he's a slave. I mean, that happened to be the merits of the case. So let's go on and decide the merits. What Taney says to that is, what? I mean, Curtis says, what? He says, hey, if a court doesn't have the power to decide a case, stop. You have a court opinion. It says no power to decide the case. Goodbye. Don't decide the rest of the case. What's the basis? See, I want to show the students of procedure that this course has direct relevance, importance, and interest in every case. Oh, that's Curtis. I don't know what the answer to that one is. And he seemed to me to have an unanswerable point there. Nobody's been able to figure out an answer. But Taney, anyway, not stop, says, now I'm going to go on to consider the next thing of whether, assuming he's free, could he be free? I mean, can they free him? Because he lived, after all, in Michigan, in Minnesota. He lived there for 2 years. He lived in Illinois for 3 years. Is he free or not? And what Taney says on this one is the following. Well, Fort Snelling, Minnesota, free territory. Congress passes a law. Says that's free territory. Congress passes a law called the Missouri Compromise. Says you're free up there. And far other laws. You're free, you're free, you're free, you're free. Okay, get the point, you're free. At least if you're going to live up there for a while. And what he says is, all those laws, the Missouri Compromise, all those laws that say you take your slave into free territory and after a while, anyway, becomes free, they're all unconstitutional. Why are they all unconstitutional? Well, here he has two reasons. The first, he says, is where did Congress get the power to enact the Missouri Compromise, to enact all these laws? Did they get it out of the Territories Clause? The Territories Clause says that Congress shall have the power to enact all needful rules and regulations for the territories. So you'd say, yeah, I guess that's where they got it. That's what it says, isn't it? No, it does say it, but it doesn't mean it. What it means is that Congress has the power to have all needful rules and regulations for the territories, which were territories in 1789. Where'd you get that one from? Well, that's what it says. And then he has some history. And Curtis says just what I said, snidely. He said, where did you get that one from? He said, there have been thousands of laws enacted since then governing those territories. What's supposed to happen to all those laws? Don't you know we bought this territory from Louisiana? It's called Louisiana. We brought it from the French. 6 states have been made out of it. Are you casting doubt? Or go ask the people in the 6 states. He says, my goodness, what are you doing when you start saying things like that? Well, says James. They still have some power. Where's the power? The power implicit in the Constitution to admit new states. Now, why is he doing that? He's probably doing that because he wants to say the real question here is, does Congress have the power to enact laws abolishing slavery in the states? And I think that's why he's trying to assimilate territories to states. Now he says, let's look at that one. He says, no, they don't have that power. Why not? Well, read the Due Process Clause. Read due process says you shall not take a person's property away without due process of law. A slave is property. You're taking it away. No process here. Don't even compensate him. Goodbye. ... End of the matter. Curtis. I don't know why you're banging on about the Territories Clause. But nonetheless, if you want to bang on about it, fine. And then he lists all the things, which are loads, of congressional statutes and rules and regulations that Congress over 40 years has enacted, and he says, are you telling me those are all unconstitutional? Please, what are you doing to the management of the country? And anyway, you're saying we start the 6th. I know buying Louisiana from the French, whether Thomas Jefferson had the power or didn't have the power, that was an issue, but water is over that dam. And the nation has decided he did have the power to buy Louisiana, and we don't know why you're opening that up again. But regardless, the real question here is the Due Process Clause. He says, now, I'll tell you something about due process of law in respect to slaves. Slavery, everyone admits, and that's been true from the time of Justinian. It's true in Roman law. It's true in English law. It's true in whenever they've had slaves. Everyone has admitted that this is a very unusual kind of property, and that it doesn't exist in any natural sense, but rather is a creature, what he said, of local law. Now, local law means the rules, regulations, statutes of a particular state, like Missouri, a slave state. Right, this man, Dred Scott, lived up in Fort Snelling. While he was there, he married Harriet. Fine. You tell me, what law is it that governs Dred Scott while he's up there? What law is it that governs Harriet? What law is it that governs Harriet's children? What law is it that governs Harriet's grandchildren? And suppose they live there for 10 generations. Are you saying that when he moves up there from Missouri, we sort of take Missouri's law and attach it to him? And he and his children are going to be up there in Minnesota carrying this bundle of law around with them, and the judge is going to have to figure it out. And now if somebody comes and does the same thing from Louisiana, of course, they'll bring their bundle of law from Louisiana, and pretty soon we have 11 bundles of law from 11 different states following some myriad of persons randomly chosen from state to state. He says that if you had a recipe for an unworkable legal system, you have found it. And moreover, if you don't think it's unworkable, ask yourself one question. These words, due process of law, go back to the Magna Carta. And you find me one case since the Magna Carta where anybody's argued that this kind of property is protected under the Magna Carta. You find one. And in England, they abolished slavery. And I didn't hear any arguments about how that violated the Magna Carta. Find one, and it's not surprising. You see why it couldn't be, And now it isn't. That's a very good form of argument. The Supreme Court, I'll say parenthetically. Archie Cox used to say that. First, get them to want to do what you want. And then show them how the law gives them the way to do it. That's a little bit that form. But my goodness. All right. So, finally, what about the fact he lived in the free state of Illinois? Well, Taney says he lived in the free state of Illinois. That's true. But the Missouri Supreme Court said he's a slave anyway, and we have to follow them. He's a slave anyway. And you could have said that at the beginning and saved us a lot of trouble. And you also could have said that and not hold the Missouri Compromise unconstitutional. You wouldn't have cast doubts on the ability of Congress to free the slaves through legislation in other places. You wouldn't have played into the fears of what's going to happen, the fears of the northern states. But anyway, he says it at the end. Missouri court decided this goodbye. That's the end of it. And Curtis says in reply, and for the proceduralists, I'm not even going to write this because it's really an esoteric point. Because the Missouri court did, in fact, decide this, but at that time they're following a case. Have you read Erie versus Tompkins? Has anybody? Raise your hand if you've read Erie versus Tompkins. Yeah, I knew it. Okay. And the case before Erie versus Tompkins that it was overturned was Swift versus Tyson. And Swift versus Tyson, which was the law then, said that a federal court will follow law, the brooding omnipresence in the sky. And in fact, the fact that a state court decides this is the law doesn't mean they're right, even if it's state law. And in certain circumstances, it's not right. There was no statute in Missouri. The precedent had gone the other way. And we had precedent all over the world for 100 years the other way. And that becomes law that he can use, Curtis. Nobody's questioned him on that at the time. And he says, you see, Dred Scott was there. He was up there in Minnesota. He got married. Hey, that makes a difference. You are a resident then. And he's a free man. A free man. But he's in dissent. Well, the case came down. There it is. Goodbye to the idea that a freed slave was a person under the Constitution, a citizen. Goodbye to the Missouri Compromise. Goodbye to something called the Northwest Ordinance. Goodbye to the power of Congress to pass laws that are going to free the slaves. And what do you think? First, I can imagine what Taney thought would happen, because there were people in Congress urging him to make all these decisions. Members of Congress said, do it, decide it, decide it. You are the Supreme Court of the United States. People will listen to you. You decide this issue dividing the country once and for all. We're coming up to a civil war. Stop that war. Once it's decided, people will adjust, and you will have stopped this terrible war from taking place. Do it, do it. And he did. So what happened? Well, some people liked it. President Buchanan liked it. There were Southerners who liked it. Some Southern sympathizers who liked it. But they were pretty much in the minority. Because what happened next was a tremendous reaction in the North. People took Curtis's opinion. They turned it into a pamphlet. And they circulated it everywhere. Taney, by the way, didn't release his opinion. He took 2 months and tried to reply to everything that Curtis had done. So we know those are his best arguments. But Horace Greeley, it's wicked, it's inhumane. Someone else, if epithets and denunciations could sink a judicial body, the Supreme Court of the United States would never be heard of again. A committee of the Senate of the state of New York issues a report which is fairly mild in its tone, aside from saying the decision has destroyed the confidence of the people of the nation in the court. It'll be overruled. And when they looked at the statement that Taney made there, they called that inhuman, unchristian, atrocious, disgraceful to the judge who uttered it, and to the tribunal which sanctioned it. They went on to say, if a master can take his slave into a free state without dissolving the master-slave relation, then some future decision of the court is going to authorize a slave driver to call the roll of his manacled gang at the foot of the monument of Bunker Hill, reared and consecrated to freedom. Huh, pretty strong. And Frederick Douglass, who was the great abolitionist, called it a devilish decision. Said, can't change the nature of things. They can't call good evil and evil good. But he says the decision is a means of keeping the nation awake, keeping it awake on the subject. And my hopes were never brighter than now. And that word awake is just what happened. It got into the hands of Abraham Lincoln. And Abraham Lincoln, who called it a legal astonisher, used it in the Douglass debates. And he said pretty much what that New York report said and what Frederick Douglass said. He said, if this court can tell Congress it cannot make the state or make a territory of Minnesota free, well, they're going to say the same thing to Massachusetts, aren't they? And they're going to say the same thing to New Hampshire. And then where are we? And plenty of people got worried about that. And he was nominated, Abraham Lincoln, and that made the difference. And then we had the war. All right, now, there are those who argue among the historians that, of course, everything would have happened anyway. There was Kansas, Nebraska. There were all kinds of things going on. And some argue that Dred Scott just really wasn't the key thing. And others say it was the key thing. But nobody says that Taney was right, or those urging him on, that this helped pacify the country. At the very best, it was neutral. And at worst, it helped feed those flames. So now what conclusions? Well, because I want to have conclusions that are relevant. And why I spent invested time in this is the more I got into it, the more I thought it does tell us something. Tells me something right now. And I can think of at least 5. 1, this is obvious, and I know it. We all know it at some level. Watch your rhetoric. What Taney did there is he didn't say this obnoxious phrase about black people. He said the founders thought, or they thought, or they would have thought. So he tries to distance himself from it. How often have we seen that kind of thing go on? It's not me, it's him. I'm just telling you what he thinks. Oh, dear. And everyone who works in my job, like other people who work in other jobs, knows perfectly well you cannot distance yourself from what you write in that opinion, where it's an opinion that people other than very technical people are going to read. So watch what you say. And I found nothing in any Supreme Court opinion. That doesn't mean I've read every one. But I could not find anything at first glance or anything quoted that comes anywhere near that rhetoric. So my own reaction is the right response in a Supreme Court opinion is what Curtis did. Rise above it. You say, oh, I see. Well, a calm consideration might lead you to a different view. And that marks it, and it expresses opposition, and it's dignified. And it expresses very strong opposition to what that rhetoric seemed to say. Well, the second thing that I think, and this is a very optimistic thing. See, I said I'd find something good here, and I did, I think. And what pleases me the most about this case is when I read the Curtis dissent, it is a dissent that is based on reason. It is not a dissent that takes emotion and feeds the emotional nature of the situation. It's da-da, 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 i.e. boring, maybe, long, 70 pages, pretty tough. But read it. You read it, and compare the logic of it, it's hard not to be convinced. And now what is it that encourages me about that? There were 3 dissents, and some were more emotional on this issue than Curtis's, but it was picked up. What was picked up? Curtis's. And that's the opinion they made the example of. And that was the opinion that was used to help persuade the waverers, the ones who didn't want to take a position. And so, to me, it says, yes, as a judge, reason counts. It matters, not just result. And I find that reassuring. Of course, you're preaching to the converted when I preach that to myself. But nonetheless, I find it very, very reassuring. The fourth respect that I find interesting and relevant is many have tried to think of what's moving Taney? Politics, or but maybe he has some politics. Yeah, if he has a political view, i.e., he sees the court in part as a political instrument, i.e., he sees the court in part as having a role to play to try to tamper down, calm out instances in which the political division in the country is fierce, and maybe as a political tool in this way we can help matters, stop thinking along those lines. Don't do it. You are not a professional politician. You are not one of the people who devotes his life to this subject. And there's a very good chance when you try thinking that way, you're going to get it wrong. And of course, certainly Taney got it as wrong as you could possibly get. So putting the best light on his motives, he's wrong. And that's the best, and there might have been some not so good. Then fourth, what I find interesting there is there any view of the Constitution that he's operating under that's coherent and that maybe gives him some support? And I could think of one. If he sees the Constitution as no more than a pact among the states, that's it, a pact among the states, sort of like a confederation, and first and foremost, as to what's being compromised there is slavery. So slavery is heart and center of the document. Slavery is the reason for being in large part, first or second on the list of the document. And it foresees moving through consensus on slavery and only through consensus. Now, that's at least a possible coherent view, though I don't think it's a truthful view, and I haven't seen historians who will support that view to any great extent. Some do a little bit. But what I think Curtis does there is he blows that view apart by saying it's unworkable. Leaving the morality out of it, it's unworkable. And he shows it again and again. You wouldn't have had a Constitution. And, of course, that isn't what the Constitution says. It says you get your 3/5 person. Okay, we give you that one. And you can have the house there as long as you can keep it. And they didn't keep it. But what about the morality? Well, of course, we could write endlessly on the morality. And we don't have to worry about that being embodied in the Constitution anymore because there was a Civil War and the 13th, 14th, 15th Amendments radically changed, destroying any temptation to see the Constitution the way Taney saw it, and instead they write a vision of the Constitution where individual rights is given equal billing with these democratic institutions. So it's not good precedent for David Scott. But the morality, and that we can figure out because it's contrary to the morality as we know it. Someday you probably read in college. It's a good book if you haven't read it. Is Uncle Tom's Cabin. I recommend it. I read it 2 summers ago. And as literature, it's a great book. Very interesting. But so she speaks better than I. But one point, the moral point, which is going to undercut everything I've said so far. I was talking about this case at some kind of seminar at one of the universities. And people are interested. I mean, it's a very interesting case for law students that's interested in law. And I imagined this. I said, now I can ask you a question. I'd like to ask you in the audience a question. I said, imagine, because I can imagine, that you are Curtis. And Nelson has just written his one paragraph. And into your office walks the Chief Justice. And the Chief Justice says, I have a deal for you. Here's what. We follow Nelson. One paragraph. It just says, Missouri Supreme Court, goodbye. Now, you agree with that, and we'll put it out as a per curiam opinion. Now, if you agree with that, you're not going to lose on Missouri Compromise. There will be no holding. You're not going to lose on even citizenship. It's too unclear. You're not going to lose on Northwest Ordinance. You're not going to lose on Due Process Clause and the states. And there won't perhaps be a civil war. And if there's no civil war, will you lose? Maybe not. Who knows who would win a civil war? That war, by the way, since I'm now looking at my crystal ball, says Taney, hung by a thread. Suppose Pickett's charge had never taken place. Goodbye, South. Slavery forever. Please, don't count on a civil war helping you. Let's try to avoid it. That's what I'm trying to do. Compromise. So you sit, think. There's a point. I ask the audience. I said, by the way, there's just one problem. Oh, Curtis should do it. One problem. One problem. Problem for Curtis. To do that, remember, he thinks Dred Scott, under the law, is a free man. And when he signs that opinion, he has sold Dred Scott into slavery. Well, says Kane, he's going anyway. Said he's going anyway. Yeah, but I can't do it. That's Curtis, all right? So I said, what should he do? What should he do? And the audience is puzzled. I mean, that's a tough one. And then suddenly a voice comes out, and the voice from the back says, say no. And everybody applauds. There we have the morality of the case. Maybe made the thing inevitable. Dred Scott, by the way, was freed. Next year, his old friend from the Blow family brought up him and Harriet. They freed that whole family, and he died a year later of tuberculosis. Taney went on to serve for some time, wrote some civil liberties opinions, merriment during the Civil War, and Curtis resigned from the Supreme Court, probably for financial reasons as well as, but he said when he left, he said, I no longer serve a purpose here. End of story. Tells us what not to do. What do we do? To be continued. Oh, I went a little long. Sorry. Thank you. Thank you. Good. At some point, that's kind of you to ask. Thank you.
There's a lot of philosophy about the difference between judicial activism and judicial restraint. So where do you get your philosophy from, and how would you describe it?
Well, let me say, I start out with the attitude most judges have. This is a starting place. Starting out, most judges will react as I did when I first became a judge, and I heard things like this: "Are you an originalist?" Roscoe Pound, who was a great dean of the Harvard Law School and created something called sociological jurisprudence, and that moved the country for 100 years, was one day said, he was talking about a particular judge, says that judge is so stupid that he doesn't know if he's a member of the historical empirical or the sociological internationalist school of jurisprudence. So I thought, well, here we are. I mean, what? I mean, what? But I have to be fair. When in the Supreme Court, there are a lot of very open questions, and how you approach those does matter. But there is no theory in my mind that's going to deduce for you answers. If you would deduce answers, why wouldn't we have the deducing machine do the job? And there is no such machine. You're dealing with human beings who have judicial training who are trying to get the answers. I probably, and it's up to other people to characterize what you do. I don't sit there and think, oh, I am a liberal judge. That's a dangerous thing to think. Cardoza got a letter from somebody who said, Judge, I heard you say you were a liberal judge. Well, I'm hard up. Can you lend me $25? So it's dangerous. I don't think I'm a conservative judge. I'd say some others have gone through, the judges that are less likely over a period of 15 years or so to strike down federal statutes, and those more likely, and I usually end up on the bottom, i.e. least likely, or next to least likely. And so you say, well, I must have some degree of judicial restraint, probably. If you read through this short book, it's not one of these totally lengthy regulatory things, called Active Liberty, I've tried to give some themes that I think guide a judge in our court on difficult, open constitutional matters. So keep in mind, this is a document that first and foremost is about democracy. It's about creating democratic institutions of government. It's not democracy 100% or its special kind. There's protection for basic human liberty. There's a divisions of powers. So nobody comes too powerful. That federal state and its three branches. There's an assurance of a degree of equality, and there's an insistence on a rule of law. All right, that sounds like a few 4th of July slogans. But what I've discovered is that those slogans actually help guide my decisions, and I believe the courts, often in very difficult cases, like affirmative action, where you wouldn't at first glance think they would, but they do. So now what I'm busy on is to try to write down a few more of those and to try to explain how a judge's decision can be guided by a certain set of attitudes which have some historical backing and which are consistent with each other and which are consistent with the notion of the Constitution as basically a democratic document that's democratic of a certain kind. And we'll see. No, I don't compare my dissent to Dred Scott. Do you mean, do I think the majority is Dred Scott? No. The morality of the situation is very different, and that is to talk about somebody else's opinion in those terms would be out of proportion, and it would be disrespectful. And Dred Scott, like Lochner, have become, like activism in a way, have become buzzwords where they become more insults than they become forms of analysis. And therefore, I stay away from insults. And the best way to approach a case in the Supreme Court, including one, and here Dred Scott is relevant, including one with which a dissenting judge strongly disagrees, is to remember this Curtis model. And the way to disagree as a judge is to explain so people can understand it, why you disagree. And the better you explain it, the more they'll understand it. Then they'll see the point. And if they see the point, a lot of things can change. Not just the point. Yeah.
Given the current administration's theory of the unitary executive and the power of the executive, and it seems like that's coloring a lot of administration decisions, and at least in some eyes leading to away from the rule of law and more toward the rule of an executive power in very difficult areas of terrorism, torture, etc. How does that challenge your view of the court and the supremacy of the court? And do you think that the court has maintained its not its relevance, but its power position in the recent cases that have overturned the executive, in the light of the fact that the executive keeps acting the same way over and over again, irrespective of the court's disapproval?
The problem of security and civil rights is an ancient problem, and it's a serious problem, and it's difficult when it comes up legally. In the cases that we've decided, when they've come to us on these questions, there have been 3 significant cases involving Guantanamo, and the executive branch has lost all 3. In the last one, the legislative branch lost 2. because Congress passed a law that said that the prisoners in Guantanamo would not have access, except under certain circumstances, which we thought were too narrow, to a federal court to bring a writ of habeas corpus. And the court held that that was contrary to the Constitution. In the prior case, the person who sued was bin Laden's driver, not the most popular person in the United States. And he sued the President of the United States, who has considerably more power. And in our court, we said bin Laden's driver was right. He didn't want, he thought that the law prevented them from trying him by means of a special tribunal of a certain kind. And we've had two others. And so those cases come as they come. And we decide them as we decide them. And so far, we have said not that the President can do anything he wants. We've said the contrary. And as to your last point, I happen to see on television, I've seen this twice now, with two opposite members of two opposite political parties. And I've been equally pleased with both as a person, not as a judge, as a person. Vice President Gore, after Bush v. Gore, told his followers, according to the movie that I saw, don't trash the court. What he's saying there is he's thinking. And what President Bush said after the last decision, which he was very strongly opposed to, he announced, he said, I don't have to like it. He said, but I'll follow. And what I don't know, but they may have, it may be that statement, but I'll follow. And Gore's statement, there, they reflect 200 years of history. Built into that statement is that terrible story of the Cherokees. It's a civil war. It's 80 years of racial segregation. It is those paratroopers in Cooper versus Eric. And it is in the attitude today that people will follow decisions with which they disagree. Well, that is, as I said, something that binds us as a nation. And it is a very, very valuable treasure for us as a nation. So when I hear them say that, the President, Vice President Gore, I say thank you. I say thank you, President Gore, for those words. In them is a history of the United States of America.